Hi, Sana. Welcome back. Can just give it a minute to see if Mr. Ronnie, Mr. Clifford, and Dikeleti will come back. So Sana, do you have any questions regarding the previous content that we discussed before we went on a break?
Hi, T. I only joined like 5 minutes before you went on a break. I was not aware of this meeting and I was busy with another meeting.
Oh,
so I'm
okay.
just gonna follow.
Okay. No, it's okay. It's okay. I know that I didn't give much notice because I was supposed to do this session yesterday and I had another meeting that we had to finalize something that evening. So it went on and on and on and on and yeah, but anyway, I'm here now. The other guys will find us on the way. So we spoke about the reciprocal duty of support, the reciprocal spousal maintenance. Is this recording? Yes, it is recording. So now let's talk about the liability of spouses for debts incurred. So what happens if a third party supplies goods or services on credit that one or both of the spouses require? Who is liable to pay the debt? The spouse. Okay, thank you guys for coming back. We're now talking about the liability of spouses when there is a debt that is incurred. So the question is, what happens if a third party now supplies goods or services on credit that one or both of the spouses require? Who will be liable to pay the debt? And the spouse who incurred the debt can obviously be held liable in contract where the parties are married in community of property. The joint estate will be liable for the debt. So if there are no assets in the joint estate, each spouse could be held liable on a pro rata basis should they have separate assets. And the third party may also be able to hold the non-contracting spouse liable for the debt on one or two possible grounds. And those grounds will refer to them as these Latin terms. Let me type it here. I tend to avoid them and only use them when I want to sound smarter. It's Negotiorum gestio. I'm not so good with Latin terms. I actually should have taken at school. We have Latin classes. I wish I had taken those classes. I should be fine. So the other term for this Negotiorum gestio is unjustified enrichment. I'm sure you have heard of this term, unjustified enrichment. The concept of unjustified enrichment is covered a lot in law of persons for those of you that are doing law of persons. Oh, okay, so we've got Amanda who just joined us. Hi, Amanda. Okay, so this Negotiorum gestio is a voluntary management by one person of the affairs of another, which without the consent or even the knowledge of the other spouse. The crux is that the person is not authorized to act. The intention is to manage the affairs of another and to recover the dominus any amount spent in this regard. The act of Negotiorum gestio may relate to the payment of debts of dominance or involve the maintenance of the spouse or the children. So let me give you an example of this Negotiorum gestio. So the example will be, so now we have the spouses that are married out of community of property. Let's say, for example, the wife is a housewife. She is not working. She doesn't have any property and she doesn't have any income. The husband is this successful business person, and then the wife is involved in an accident, for example, at home, while the husband is somewhere overseas on a holiday, and wherever he is, he cannot be contacted. And then now the wife has this accident and she's unconscious and she needs an urgent life-saving operation. And then now we're talking about the spouses, although the husband is successful, but these people don't have any medical aid or any health insurance. And then the doctors, the scenario is hectic. The doctors at the government hospital, they are on strike and they are not available, or they are not able to help her at that time. So then now we have this neighbor. The neighbor decides to take her to hospital because she can see that this person might die because there's no money. Public hospital doctors are on strike. They can't get hold of the husband. Then the neighbor takes this woman to hospital, and then she pays the deposit of 30,000 rand so that she can be admitted, and then she can undergo this operation with the assumption that when the husband comes back from wherever he is, Italy, whatever, she will get a refund. So on return from his holiday, the neighbor submits the account to the husband, but the husband refuses to pay. And then he argues that he did not contract with the hospital and he did not agree to the expense. So what would usually happen, because he's going to be thinking that, well, most people would obviously think that because now we are married out of community of property, it means that I'm not liable for that debt. But in actual sense, the neighbor will be successful with that claim based on the principle of Negotiorum gestio. So all the costs that were incurred were necessary, and the reasonable medical cost is not like the money that was maybe spent on gambling or something like that. So, and the neighbor intended with the good intentions to manage the affairs of the husband and to recover from the from the husband all the expenses that were incurred. So if given that scenario, regardless of the matrimonial property regime that the couples have entered into, the claim will be successful because it was for a life-saving situation, and the husband also has a reciprocal duty of support to his wife, irregardless of the matrimonial property regime that they entered into. So even if it's in community property or out of community of property, there is still that duty. Although that duty might be limited to certain things, but in this particular scenario, if you're given this scenario, the neighbor will be successful on that particular claim. Sorry, there is somebody sleeping. So if you do hear in the background, somebody snoring, yeah, they're sleeping like a baby. Okay. let's talk about the next one, which is unjustified enrichment. Is exactly, not exactly, it's the same like Negotiorum gestio, the one that we spoke about. So the principle of unjustified enrichment applies if one spouse unjustly obtains a patrimonial advantage at the expense of a third party. This enriched spouse must then reimburse the impoverished party. A third party must provide the following. First, there must be the actual enrichment of the one spouse. And then secondly, the enrichment must be at the expense of the impoverished party. And then thirdly, the enrichment must be unfounded. And the last one, there must be no rule of law that denies the right of restitution of the impoverished party despite the presence of the other elements. So I'll give you an example which for unjustified enrichment. So when using the facts that I stated just now, the neighbor will be able to claim the 30,000 rand deposit from the husband as medical costs fall within the ambit of the duty of maintenance between the spouses. I think I've already explained that. So the husband was enriched with the amount as he would have had to pay it had he not been away on holiday. So the neighbor was impoverished by the same amount. There is no other foundation for the enrichment and no rule that would deny the neighbor their right to reimbursement. So let's see if I can find another example. Another example will be, let's say you have a child that is 15 years old, and then the same scenario, you are away on holiday or wherever, and then there is something that is like required at school, and then because you are away and you are unreachable, then your neighbor decides that they're going to take out their money and then pay for that for your child at school, so that they can be able to, continue going to school or get whatever it is that they need. And then when you come back, you're like, no, but I didn't agree to this. But you have a duty of support. You have a responsibility to take care of your child, regardless of whoever assisted at that time. So it means that if you refuse to pay, it means now you are unjustifiably enriched by that particular person who has taken your responsibility, because now you still have the money that you could have paid. Should you have been around, you obviously would have paid for that particular thing that your child needed. Okay. Is there any questions before we get to the household necessaries? Any questions? Sana, Amanda, Clifford? No? Okay. The household necessaries. The general principles of household necessaries. Part of the duty of support is the liability of household necessaries. The rules in this regard provide the legal basis for one spouse to bind the other spouse in contract to a trader, provider of household necessaries, irrespective of the matrimonial property system. The rules, which are the same for both the husband and the wife, are as follows. Spouses married in community of property are jointly and severally liable for debts incurred in respect of household necessaries, irrespective of who purchased the goods. Spouses married out of community of property are also jointly and severely liable for any debts in respect of household necessaries. The duty of support falls on both spouses to contribute to the necessaries of the joint household, pro rata according to their separate financial means. A spouse married out of common of property after the commencement of the Matrimonial Property Act has no right of recourse against the other spouse for any excess contribution made in this regard, unless contractually provided by the spouses. So before we continue, let's distinguish between the duty of support that we spoke about and the household necessaries, so that it doesn't become it doesn't become confusing going forward. So the difference between these two is that the duty of support between the spouses and the duty to contribute to household necessaries, they do overlap. There are instances where there is no overlap. I think the textbook, I don't know the textbook that you guys are using, I think it's Sinclair and Heaton. I'm not too sure, but I think it's something like that. There are examples, a textbook that says certain goods or services may fall under household necessaries, but are not part of the duty of support, such as clothing of the spouse who is liable for support. So these ones are, and then the other one says some goods or services fall under the duty of support, but cannot be regarded as household necessaries, for example, litigation costs. So the household necessaries, so we will be looking at something like clothes, something like food. Those are the things that are necessary for any household to survive. And then let's say on this one, they used litigation costs, like let's say maybe the other spouse is being sued, going to court, maybe paying for bail or something like that. Those things, they have nothing to do with the household, with the survival of the household. So let's move on to the requirements for the liability to purchase household necessaries. In general, the liability to purchase the household necessaries depend on the existence of a valid marriage and the existence of a joint household. The existence of both of these is a question of fact. However, the mere fact that the spouses are married and now have a duty to live together does not mean that a joint household has come into existence. Where it is clear from the facts that there is no joint household, a spouse is not liable for the purchase of household necessaries. Once spouses have established a common household, the liability comes into existence and endures despite the temporary absence of one of the spouses. Where the joint household no longer exists because the spouses live apart, creditors can hold the non-contracting spouse liable for Negotiorum gestio or unjustified enrichment for accommodation, food, clothing, and the like provided to the other spouse. For one spouse to have the power to bind the other spouse, the goods purchased or services contracted must be household necessaries that are reasonably necessary for the joint household. To determine whether the contract is reasonable, a court will consider the following circumstances. One, that will be the financial position and the means of the spouses or the family. The social status of the spouses or the family. The standards living of the spouses or the family in the past. And the practices and customs in the area. There is cases, these are not really relevant cases. You can just read them by yourself to try and get clear examples, I'm just going to type it here. Just type it here. No, not this one. You can just look at the summary of these cases, and then that's where they will you will see like some supporting facts, and then you can be able to formulate your own examples. So the power of one spouse to bind the other spouse in respect of household necessaries is terminated in the following ways. When the marriage is dissolved by death or divorce, then you're not going to be able to bind your spouse with regards to the household necessaries, or when the joint household comes to an end. What does that mean when the joint household comes to an end? So when you live together with your wife as husband and wife under the same household, where you share the duties of the household, to say, okay, I'm working, you're working. This is how we live. Obviously, I don't know if those kind of arrangements are made verbally, or it's something that just comes in without saying anything. But let's say in a case where there is a verbal informal agreement to be like, okay, you take care of this, I take care of that, or even without saying that, okay, this is what you're gonna do, but that support coming naturally. So that is that's what is considered as a joint household. And then if it is clear that even though these two people live together, but they live like separate people, they have maybe different stoves or different pots, that when the husband comes back from work, he will cook his own food, and then the wife is not supposed to touch it, and then the wife does the same. There is obviously no joint household in there. So the duty of household necessaries is not going to exist in that type of household where people live their separate lives in that kind of setup. So I think this was actually the last one. I'm just going to share these. I would like you, I think because of time, we're gonna have to, it's already 25 minutes after 11. I'm just going to share this, and then you can actually check it on from your textbook. And then if it does come out that you don't find anything, you can just text me or give me a call, and then we can talk about it. That's the donations between the spouses. And then under that topic for the donations between the spouses, there is a case of Snyman versus Reader. It says number 100. I don't know what that 100 is. I think you can just check that. You can just check that case. Snyman versus Reader. That. And then is the one that talks about the donations between the spouses. You will also find some information on section 22 of the Matrimonial Property Act. So yeah, I'll just go through the chapter, this particular chapter that we spoke about in summary, and then I think we can call it a night. I can see Mr. Nguna is yawning. He probably needs to go to bed. So okay, we spoke about the marriage. We said marriage results in personal consequences that occur automatically, and these personal consequences, they relate to the status of the spouses. Consortium omnis vitae, the reciprocal maintenance duty of support between the spouse, and the regulation of the right to purchase household necessaries. And then the examples of personal consequences relating to the status of the spouses include, we say the marriage creates new relationships by affinity. Minors attain majority when entering into a valid marriage. A spouse has the right to inherit interstate from the deceased spouse. I know we didn't speak about that. I said you can go and read it by yourself, but you can just note it. A spouse, a wife may take the surname of a husband without the consent of the Director General of Home Affairs. Both parents have equal parental responsibilities and rights towards their children born of the marriage. So those would be the examples of the personal consequences relating to the status of spouses. And then number 3, the marriage creates a consortium omnis vitae, which can be described as a physical and moral and spiritual community of life. The threat of divorce protects the consortium indirectly. In the light of the changing mores of society, the innocent spouse's delictual action based on adultery is outdated and no longer form part of our law. The delictual claims of enticement and harboring protect the consortium against the third party's interference. And then number 4, we say there is a reciprocal duty of support between spouses during the marriage. The spouses must contribute according to their means, and the consequences of this duty include the following. The amount of maintenance depends on various factors. The law makes provision for the right of both spouses to live in the matrimonial home. The maintenance obligation of spouses ends with the dissolution of marriage, except where they agree otherwise, or a court makes an order to the contrary. The surviving spouse may be entitled to maintenance after the death of the other spouse in certain instances. And the duty to maintain a spouse may continue even after separation. A third party who supplies goods for the maintenance of a spouse may have a claim against the other spouse based on Negotiorum, gestio, or unjustified enrichment. Number 5, a spouse may bind the other spouse for payment of household necessaries, irrespective of the matrimonial property system. The requirements for the household necessaries principle include a valid marriage, a joint household, and that the goods are in fact the household necessaries. And there are 2 approaches to determining household necessaries, namely the subjective and the objective approaches. And lastly, the one that I said you can go and read by yourself is with regards to the donations. Donations between spouses are in principle valid and subject to the insolvency legislation. So this is just a recap of what we covered today. If you have any question, you can ask now, or if the questions are going to come later, you can send that to me, and then we can talk about it. Yeah, so I know that I was not available for quite some time. I was super busy, but looks like things are getting back to normal now. So I will be available when you text, call. I will be available, though with regards to calls, sometimes I'm not able to. So is there any questions before we call it a night?
No, on my side, no question. Thank you.
No question at the moment.
Okay, no problem. Any question, Mandla?
No question at the moment. Ntunga.
Okay, ngiyabonga mina. Okay, Sana, no questions, Amanda? Okay, I'll take that as a no, and I would like to thank you guys for keeping me company this evening. I thought I was the only one that stays until 3 o'clock in the morning, but hi, ngiyabona ukuthi we are all hustling out here.
Yeah.
So, yeah, so thank you so much. I'm gonna call it an evening, and I will see you guys soon. I think maybe tomorrow. No, tomorrow I'm not gonna be available. Maybe Friday we can look at the patrimonial consequences of marriage. But yeah, we will talk on WhatsApp, and I will see you guys soon. Take care and good night.
Good night,
night.
T.
Thank you.